numbers at the countrywide public hearings facilitated by Parliament's Social Development Committee on the Children's Amendment Bill. Among the issues that the Children's Amendment Bill covers are improvements to foster care services for children, parental responsibilities of unmarried fathers, child marriages, services for children born to foreign parents, and unaccompanied migrant children. And for many, at the coalface of the law, the issues are not always clear-cut. Unfortunately, the consequences are sometimes irreversible.
She was actually a very friendly child, always laughing, always running up and down. She was never without a smile. She was really an angel, and my princess.
An angel to her mother, gone too soon. Her favorite toy, this black scooter, is a painful reminder of little Annika, whose life was cut short in April this year. She died under mysterious circumstances, aged 5 years, while she and her 2-year-old brother had been placed in a temporary safe home by a social worker. They were never to return home. This is Annika's brother's 2nd birthday, also celebrated by their mother, whom we will call Mary, to conceal her identity, to protect her minor son. This is one of the 3 times that she visited them at the Safe and Soft Landings home. She says on her last visit, her daughter was not feeling well. It was the last time she would see her alive.
When I came there, they just told me that my daughter is not feeling well, she's a bit sick. So when I saw her, that she has some sort of sore on her nose, and she looked very pale. I asked her what's wrong, and she just responded with a stomachy sore.
Tragedy struck 2 days later. Mary says her nightmare began with a call from a staff member at Safe and Soft Landings.
She phoned me like about an hour after, telling me that they want me to come to the safe care house and it's not going well with my daughter. So I went there with my mother, and when I came there, they just told me that they were doing CPR on her, and then they couldn't save her. She didn't make it.
The little 5-year-old's life was cut short before it even began. Mary is still waiting for the autopsy results to clarify the cause of her daughter's death. The Safe and Soft Landings home says it cannot comment on her death as there's an investigation underway. A month after Annika was removed from her home, Mary bid her final goodbye as friends and family joined in to lay her to her final resting place. While still reeling from the shock of what she believed was her daughter's sudden death, she was dealt another blow after she accidentally found out that her son had also taken ill.
Later on that night, I received a message from the medical aid with an authorization number. And I just didn't really understand it. And the next morning I got an email with all the information on that my son has been admitted. So they didn't call me to tell me that he's going to hospital. They didn't call me to tell me that he's in hospital or sick or anything. I found out that my son is in hospital through the letter from the medical aid.
The medical aid letter states the reason for admission as a toxic effect of an unspecified substance. He was discharged the next day. But what were the circumstances that led to these children being taken away in the first place? And was there enough justification for their removal? The story is not clear-cut. Children are caught between the extremes of a parent with a history of mental instability and a social worker who just may have taken the children from the frying pan and into the fire in an attempt to save them. On the 19th of April 2021, Mary buried her child who died under mysterious circumstances at a home where she and her younger brother were taken by social workers who claimed that they were facing imminent danger. She recalls the day when a social worker from the Suid-Afrikaanse Vrouwenfederasie, or SABC, a child protection organization, removed her 2 children from her care.
I came home from the hospital that night, and then when I got home I was told that the kids has been taken that afternoon by the social worker. And they were taken from school with a form 36 that was not signed, and they just told me that the kids was not at school when they went there to pick them up.
A Form 36 is a document used by social workers to seek a court order to place children facing imminent risk in temporary safe care. The use of the form has been controversial in the child welfare sector, with some accusing social workers of failing to do their due diligence and resorting to the form when the situation is unwarranted. Wiseman Kalishwayo, an attorney in Benoni, east of Johannesburg, specializes in, among other things, family law. He says the form does not meet constitutional muster.
It's unconstitutional on the basis that it does not give the parents who are alleged to be not caring for their children an opportunity prior to the decision to remove, to state their case and their version being heard. It's more give authoritative powers to the social worker.
But the Department of Social Development defends the use of the form.
Before issuing a Form 36, one would hope that social workers will do that investigation. In some instances, there's a crisis, and that is when the social workers should use the Form 36 to remove the children to a safe place and then take it to the court to confirm the Form 36 with a court order to legally place the child in the care of the safe parent or the facility.
According to the Children's Act, upon being given an order that a child must be moved to a temporary place of safety, the social worker has 90 days within which to conduct an investigation that will determine whether the child faces imminent danger, in which case the child will be placed in permanent safe care. But if not, the child should be reunited with their family. Kalishwayo argues that the 90 days waiting period may not necessarily be in the best interest of the child and calls for the review of the use of the form.
The new environment brings a trauma, brings some sense of shock to the child. It's a shortcut into the issues in question, because if you go for Form 36, you are taking shortcuts, but where you go for Form 22, that will means you initiate the matter in the children's court for investigation, which will now result in the actions that are now necessitated by Form 36.
He insists that instead, Form 22, which initiates the matter in the Children's Court, should be enforced as a first option, except under exceptional circumstances.
An emergency situation must be something that was unforeseen, that happens in a blink of an eye, not something that has been going on for some time.
Once you start implementing the Act, you will actually now realize, but there's shortfalls or things that's not working properly, like for instance around the Form 36. Initially, the Act did not prescribe that a social worker should take the Form 36 to court the next day. It just indicated that the social worker will have 90 days to do the investigation. And that was then found not to be proper. So the Act was amended in 2016. It's always ideal that the social worker should properly investigate the circumstances of the children, of the parents, to ensure that the children are safe in the care of the parents.
So, on objective facts, was there a crisis in Mary's situation requiring the use of the Form 36 to place her children in temporary safety? Mary argues that though the official reasons used to remove her children were neglect and a lack of food in the house, she believes she was being victimized due to her mental health condition.
I didn't always bought food like monthly and stock the cupboards and everything. Usually some days I would get food per day or per week. So they did eat every day. They even got snacks in between. They ate like 6 meals a day, included with the snacks. And then the other allegations or reasons they made was I'm unstable because of the bipolar, and then the other one was they were accusing me of using drugs.
Mary has been living with bipolar personality disorder and has been on medication since 2011. She argues that her health was not a concern when the children were taken, as their father was looking after them. She has been admitted to hospital for treatment on several occasions. The South African Constitution prohibits discrimination on the basis of health. If her condition was the reason for her children's removal, could the social workers have been justified in removing them?
It's important for social workers to make that initial assessment and look to putting the children with someone who is a more responsible, caretaker of the children before removing the children to a strange, unregistered child and youth care centre.
In a statement issued by Child Protection Services Organisation, SABC, the social worker says she acted in the best interest of the children after she was informed that Mary was suicidal.
There's a lot of people in the world that have bipolar or depression, and they also have kids. They also take care of their children. So why is there a problem of having kids and having bipolar?
In a statement, the social worker acknowledges that having a mental illness does not necessarily take away a person's right to be a parent if the parent is receiving psychiatric care and strictly adheres to prescribed medication. After a letter from Mary's doctor, dated 27 May this year, states that she had been receiving treatment for bipolar disorder since she was a teenager and that there had been no indication that she was purposefully neglectful to her children.
I think I can still be a good mother with bipolar. The condition doesn't make me a bad mother. It doesn't affect the way I feel about my kids or the way I take care of them.
If someone is physically ill, we tend to have loads of sympathy. When it comes to mental illness, because we cannot see the wounds inside the person's head or inside the person's heart, we lack that same sense of empathy and compassion.
Allegations of drinking dangerous substances complicate this matter.
Sanitizer, no, I have never drank sanitizer at all. Just the smell of sanitizer is putting me off. I will never drink sanitizer. Methylated spirits, I did drink it before, but it was last year. By the time they took my kids, I was clean for already 5 months. So I was not on spirits when they took the children at all. All of my other drug tests is clean, not even dagga in my system.
Mary's story clearly shows a history of a struggle with substance abuse, given that she admits to having taken methylated spirits, though she seemed to have had it under control when her children were taken. The social worker says, while she had no evidence of this allegation, she still believed the children were in imminent danger, given all the allegations made against the mother. But, given the fact that Mary had been sober for 5 months, was the removal of her children in their best interest and legal under the circumstances?
Removal is one of the most serious actions a social worker can take. You are interfering with a parent's rights and responsibilities. You are interfering with a child's rights to parental care. It has to be done with very, very careful assessment and planning. It should be done ensuring that you're taking the children from an unsafe place to a safer place.
As Mary awaits the autopsy results detailing the cause of her daughter's death, the legal standing of the home at which the children were temporarily placed has also come under scrutiny. Special Assignment was informed that despite it being an unregistered entity, social workers were placing children at this home called Safe and Soft Landings in Pretoria. 13 children had been placed at the home.
The Centre Safe and Soft Landings was not approved as a place of safety, as it is prescribed in the Children's Act. The staff working there were not cleared in terms of the Child Protection Register to indicate that they are safe and suitable to work with children.
When we visited, we found that all of the children had been removed and staff members referred us to the owner, Lizelle Oosthuizen, who spoke to us through her lawyer. She says that her home is a registered non-profit company that had been inspected by Christelike Maatskaplike Raad, or CMR, a child protection services organization that certified it safe to accommodate the children. But the Department of Social Development denies that it's a properly registered entity. It adds that although Lizelle Oosthuizen, the owner of Safe and Soft Landings, is cleared against the Child Protection Register, she is in breach of the Children's Act. She was supposed to operate as a foster mother with no more than 6 children in her care. The facility was also not approved or declared suitable by the Department of Social Development. But how could social workers continue placing children in an unregistered entity, and whose responsibility was it to verify its status?
I believe the presiding officer should, before they place a child in the care of individuals or a facility, they must ensure that that person is approved with a Form 39, or in the case of a facility, that it's approved or registered according to the Act.
This means that from September last year to April this year, this entity was operating and no one noticed. The department says it only became aware of Safe and Soft Landings after the death of Mary's daughter.
So the death was reported to the department, and immediately we've sent out social workers to investigate what was the cause of the death and what is happening at the facility.
After her child died at a temporary care facility, who must be held accountable? The social worker who placed the children does not work for the state, but for an independent organization.
If something happens to my child at the time the child is at the home, who is to account? There must be a clarity on that grey area.
The mother can at any stage contact a lawyer to start with a civil case in this situation.
The place of safety itself bears responsibility. I do think that Department of Social Development needs to kind of look at that response, especially in view of the fact that this mother is a vulnerable young woman. I don't believe that any of us should wash our hands of this kind of scenario.
But for Mary's daughter, whatever amendments are made to the Act, they will be too little, too late.
I keep thinking by myself that if they didn't take my children, that my daughter might still be alive. If I can get answers and the truth, I think that can be justice.